Hello, government students. This is your instructor, Elizabeth Floyd, and I'm going to do a lecture on the legislative branch for Learning Module 5. This slide just shows the objectives, the things that I hope you'll be able to accomplish once you've completed Learning Module 5. We're going to start out with a fairly general overview of the legislative branch. The legislative branch, as you probably already know, is the lawmaking branch of our government. So it consists entirely of lawmakers. It's the representative branch of government because the people that we elect to the legislature, the legislative branch, they speak for us. So they are our representatives in the national government. They are there to speak on our behalf. Because they are elected by us, by the people, and not by any sort of intervening body, they'd be considered the most democratic branch of our national government. You might recall from reading, I believe it was the Federalist Paper number 51, the author said, in a Republican government, the legislative authority necessarily predominates. And I'm highlighting that because I want you to understand that when when our government was first formed, our national government, the expectation was that Congress would be the busiest branch, the one that played the most dominant role in American lives. That may be up for debate considering the current political climate. But the legislative branch was formed by Article 1 of the U.S. Constitution, where it says, all legislative powers herein granted shall be vested in a Congress of the United States. So I want you to make a note of this real quick. When we're referring to our national legislature, we call it Congress. But each state has its own legislative branch. And at the state level, that branch tends to be called the legislature. So make sure you're noticing that maybe as you're reading the news or doing work for this class, Congress is the national legislative branch. When you see references to the legislature, that's going to be a reference to your state government. Okay, so Congress is what we call the national legislature, and that was provided by the U.S. Constitution. And the very next clause, it says, which shall consist of a Senate and a House of Representatives. That's bicameralism. That means that our legislative branch, our Congress, consists of two chambers. So this was a product of the Great Compromise, that we would have a two-chamber Congress. The Senate, which is sometimes referred to as the upper house of Congress, originally, interestingly enough, state legislatures elected senators, not the people of the states. So that was part of the sort of the design of our American federalism, was that the state legislatures would be represented in the upper house of Congress. And the way we accomplished that was that the state legislatures would be the ones to elect members of the Senate, so that the Senate was really there representing state legislatures. Now that changed with an amendment to the U.S. Constitution, the 17th Amendment. So now it is the senators are elected by the people. And these two gentlemen now that we have on the screen are the senators from the state of South Carolina. I just wanted you to see what they look like in case you may probably already know, but just in case, we have Lindsey Graham and Tim Scott, who represent us in the U.S. Senate. The next chamber of the Congress is known as the House of Representatives. Sometimes you see it referred to as the lower house, but don't read anything into that. They have equal power in government as senators do. And I have a picture of the representatives from South Carolina too. This is Nancy Mace representing the 1st District, Joe Wilson representing the 2nd District, That's Sherry Biggs. She represents the 3rd District, which actually includes Greenwood. So she's representing Greenwood County in Congress. She's the newest one, the newest member of our congressional delegation. Then this is Bill Timmons from District 4, Ralph Norman from District 5, Jim Clyburn from District 6, and then Russell Fry from District 7. So this is the entire congressional delegation from the state of South Carolina, our 2 U.S. senators, and then our 7 representatives in the House. The 2 chambers are somewhat different, and that's just a product of some differences established in the U.S. Constitution. First of all, in order to be a member of Congress, you have to meet certain qualifications for office, and they're slightly different depending upon whether it's the Senate or the House. The qualifications each relate to a person's age, the length of their citizenship. They must be citizens of the United States of America in order to serve in Congress. But members of the Senate have to be citizens a little bit longer than members of the House. So that's age, citizenship, and then residency. Residency in the state they're representing. Members of the House must be residents for a slightly shorter period of time than members of the Senate. So these are relatively minor differences, but they are slightly different, and they relate to age, citizenship, and residency. But here's where the differences become more apparent. Members of the Senate serve for 6 years, and they represent the entire state. So Tim Scott and Lindsey Graham represent all of us, everybody in the state of South Carolina. Members of the House only represent certain congressional districts, and they're there for only 2 years. So that means every 2 years they are up for reelection. So they are very closely tied to the more pressing local interests of their electorate, of their voters. They're there to address the more time-sensitive issues. They're going to be more apt to move quickly, push bills through Congress quickly. And because they have fewer constituents, they're representing just a smaller district within a state, they can be more responsive to their electorate, the members of their district. In the House, we'll see when we talk about, how a bill becomes law, there's a rule in the Constitution that the House of Representatives is the body that can introduce tax legislation. So that would make sense that they would be more closely tied to their constituents because they're responsible for initiating any taxation or changing taxation. There's no term limits for either the Senate or the House of Representatives. They can continue working in Congress indefinitely. But just note that there is a difference in the number of years. The Senate is there. The people elected to the Senate serve for 6 years. That's a longer term. They can sit back and work more slowly, get a bigger picture of the impact any legislation may have before they approve of it. Whereas in the House, they must act more quickly to get things done so that they can go back to their electorate and say, hey, I got this bill passed for you. Won't you reelect me? Only 2 years later. That means they have to move quickly. As I said earlier, that the Senate represents the entire state, which means they have to have a broader based appeal for the legislation that they propose, and the House represents a district within a state, so they can address more local pressing concerns. So next, we're going to talk for a minute about the powers of Congress. In general, Congress has lawmaking powers, all right, because they are the legislative branch. That's the business of a legislature, is to make laws. But we'll look for a second at the specific laws that they can pass. I'm going to click on this link here that's going to take us to Article 1, Section 8 of the U.S. Constitution. Okay, I'm scrolling down here. Section 8 is right here, and this is a list of the enumerated powers of Congress. Let me see if I can make it a little bigger. There you go. Congress has the power to lay and collect taxes, something I already mentioned just a second ago. They can borrow money on the credit of the U.S., they regulate commerce, they govern naturalization and immigration laws, they're responsible for coining money, punishing counterfeiting, establishing the post office. They will, it says, promote the progress of science and useful arts. That relates to copyright, trademark, patents. They regulate that process. To constitute tribunals inferior to the Supreme Court, that means they established the federal court system that operates underneath the U.S. Supreme Court. I'll explain that a little bit more later, but that actually is a rather sizable amount of power to create courts and then regulate their operation. Then they define and punish piracy. They can declare war. They can raise and support the Army and a Navy. They will then make rules for the regulation of the Army and the Navy. They can provide for the calling up of a militia. Nowadays, that's more or less the National Guard. Then they organize armed discipline and so forth, the militia. They can exercise legislation over a variety of different smaller institutions within the national government. And then the last is the necessary and proper clause, or the elastic clause that we studied in connection with federalism, the last unit of study. This is Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. So when it says foregoing powers, they're talking about all of these listed here. So it's not a completely open-ended source of power. All laws must be directly connected with an enumerated power. All right, I just wanted you to kind of get an overview of the types of laws that Congress can pass. These are the enumerated powers of Congress, the specific laws they are allowed to pass. But let's see if I can get back to the slideshow. Okay, now we're back to the slide here. And again, what I had just gone over was the enumerated powers of Congress. There's an additional location where you might find enumerated powers, and those would be in some of the amendments to the U.S. Constitution. The Reconstruction Amendments are something we spoke about briefly with the last unit. At the very end of the 13th, 14th, and 15th Amendments, there's a clause that empowers Congress to pass legislation relating to the subject of those amendments. So, for example, in the 13th Amendment, which abolished slavery, there's a provision in the amendment that allows Congress to pass laws to carry out the abolition of slavery. So this is an example of where some additional enumerated powers were given to Congress later, after the Constitution was first ratified. Congress has what we call the power of the purse, because you probably noticed many of those enumerated powers in Article 1 have to do with money. Congress is in charge of collecting taxes and then distributing tax money through various activities of the national government. So that's why they are considered as having the power of the purse. They manage the national budget, the income, revenue that comes in, and then how that money is spent. In addition to being given enumerated powers, the Constitution also denies certain powers to Congress. That comes a little bit after. So, Section 8 gives power to Congress, Section 9 then denies certain specific powers to Congress. And that denial of power is connected to civil liberties, which is something we'll cover later in the semester. So, I won't go into depth on that. I just wanted you to be aware that it exists there. I want you to recall now the study that we did in American federalism. And we looked at a particular case called McCulloch versus Maryland. This was the big bank, national bank case. When we were studying federalism, we focused on that decision because it enlarged the power of Congress. And they enlarged it by interpreting the necessary and proper clause that I read to you just a moment ago. That decision used the language of the necessary and proper clause, or the elastic clause, to allow Congress to establish a national bank, even though the power to establish a bank was not among the enumerated powers. It was simply implied by the enumerated powers, and it was necessary to carry into effect the enumerated powers. That's why Congress was allowed to move forward with establishing a national bank. But that doctrine, then, the doctrine of implied powers, has allowed Congress to expand a bit beyond what originally was authorized to do. In addition to enumerated and implied powers, there are some powers that Congress carries out that are simply inherent to the nature of a national government. They are so obvious that we don't really have to analyze them and look for their source. I'll give you an example. This is from your textbook. Congress sets the borders of our nation. So the line between Mexico and the United States, the line between Canada and the United States, those national borders were drawn by Congress. And that's not written anywhere in the Constitution, the power to do that. But how else would we have borders were it not for our national legislature drawing them? So it's inherent to their existence to be able to do that. So there's just a few things you would consider inherent powers. Then otherwise, we have enumerated powers, which I've gone over. And implied powers just comes from the operation of the necessary and proper clause that has allowed Congress to expand a bit upon its enumerated powers, provided they can make a connection back to one of the listed or enumerated powers. The next type of power Congress has, and this isn't really different from lawmaking, but Congress has a lot of oversight of the activities of other branches of our government, which seems logical since they are our representatives. They're going to be watching what the national government is doing and making sure that it is being held accountable to the people. But this is also an element of checks and balances. So remember that separation of powers means dividing up government power among the three branches. Checks and balances is the way each branch can sort of control the activities of the other branches. It's also how the branches are forced to cooperate with one another because they can't do anything truly alone. So here's some examples of how Congress oversees the executive branch. Congress can override the president's veto. So Congress writes a law, sends it to the president to be signed and then officially enacted. If the president decides not to sign a bill and vetoes it, it'll go back to Congress, and Congress has the authority to vote again. And if there's a supermajority in Congress in favor of the law, they can override the president's veto. And then the bill will become law, even against the wishes of the president. Congress can also confirm the appointments made by the president. You will see that in the news a lot right now. In February 2025, Donald Trump is making a lot of appointments to the executive branch, and it is the job of Congress to vet those nominees and determine whether they will be confirmed and able to actually serve in the national government. The next check and balance power is impeachment. This is a power that is given directly to Congress in the Constitution, the power to impeach the president. And then Congress has the oversight over executive agencies. So these are the various departments and agencies of the national government, such as let's see, the SEC, the FDA. You can think of all the various bureaucracies within the national government. They have to answer to Congress. Congress will hold hearings to evaluate the work that those federal agencies are doing, and determine whether their budgets are justified and if they are operating effectively and efficiently. It's Congress's job to do that. Congress also oversees the judicial branch. That would be the court system. As I mentioned previously, among the enumerated powers of Congress is the power to establish the inferior courts, so the lower courts of the federal system. The U.S. Supreme Court is set up by the Constitution directly, but no other courts were. Instead, that power was given to Congress to sort of flesh out the federal court system. The Senate will confirm the president's appointment to the federal judiciary. So this is sort of similar to confirming appointments to executive departments. The president will nominate someone to serve as a federal judge in the federal court system, and then the Senate confirms those judicial appointments or not. They can reject a nomination, and then the president has to go back and pick someone else. So these are just the ways that Congress exercises its checking and balancing or oversight power over the other two branches of government. This is a large portion of what Congress is responsible for doing. Okay, now we're going to look at exactly how Congress is organized. There are 535 members of Congress. That's a lot of people. So organization is essential. Within each chamber, within the House and within the Senate, there are political party conferences. So political parties have a lot of influence over the lawmaking activities of Congress. So there's going to be a Republican conference in the Senate, a Republican conference in the House, a Democratic conference in the Senate, and a Democratic conference in the House. And they are going to coordinate the lawmaking activities in order to favor their party platform. So beyond those conferences, there is also a hierarchy within each of the two chambers. So I'm going to separate them out now and show you what that hierarchy is. Within the House, there are 435 seats or members of the House of Representatives. It's a lot of people, requires a lot of organization. At the very top of the hierarchy sits the Speaker of the House. That currently is this guy, Mike Johnson. And you can see where he's positioned there. I wish I had a better picture, a broader picture to show you the floor of the House. But the Speaker of the House sits at the very top of a platform and has that little gavel there that Representative Johnson is holding. And that's just to demonstrate that the Speaker of the House has a lot of administrative control. But he is elected by the entire House of Representatives. So all 435 members of the House will elect a Speaker of the House. But as you might expect, political parties, here's where their influence comes in. The majority party in the House will obviously pick a member of their own party to serve as the Speaker. And since the Republican Party holds the majority in the House of Representatives, Mike Johnson is a Republican, and he is currently the administrative head of the House of Representatives. This is a constitutionally established role. the Constitution requires the election of a Speaker of the House and makes the Speaker of the House next in line to be the president after the vice president. So the line of succession goes president, vice president, Speaker of the House. That's in the Constitution. As I mentioned, that he is the administrative leader of the House. He, for example, makes committee assignments, tells the other members of the House what committee they'll serve on. He will be the spokesperson for his or her party. So Mike Johnson being a member of the Republican Party, he will speak for the Republican Party in the House of Representatives. But he also has his own constituency. He was elected to the House of Representatives by the 4th District of Louisiana. So he does have to speak for his own constituents as well. Beneath the Speaker of the House, you have the party conferences, and that would be the majority leader and then the minority leader. We're talking about the parties again. The Republican Party will elect the majority leader now because the Republican Party has control over the House of Representatives. Currently, the majority leader then is Steve Scalise. He is a Republican, and I do not recall what state he serves from. And then the minority party would be the Democratic Party. The minority leader is Hakeem Jeffries. I believe he represents a district from New York. There are also the next in the hierarchy. So you have Speaker of the House, majority and minority leaders. Then you have majority and minority whips. These are representatives who do most of the negotiating on legislation, trying to keep their party's support for particular pieces of legislation solidified. I don't have pictures of them in the slide. This is a slide just to show you the political party balance in both chambers of Congress so that you could just kind of visually see that the Republican Party being red has a slight majority in both the House and the Senate. Right now, we'll look a little bit at the organization of the Senate. It's a smaller group of people, so there's a little bit less organization to it. But at the very top is the person we refer to as the president of the Senate. And according to the Constitution, the president of the Senate will always be the vice president of the United States, currently J.D. Vance. The president of the Senate has no voting power. They're there simply to break ties. Because we have 50 states, each state having 2 senators, you've got 100 senators. That's an even number. So you need someone there to break a tie quite often. Yeah, and as I said, it's constitutionally mandated. Beneath the president of the Senate is the president pro tem. This person is going to serve only when the president of the Senate is unavailable. And that is a picture of the president pro tem, Chuck Grassley. It is a constitutionally mandated position as well as the president of the Senate. There's J.D. Vance. I thought I had a picture of him in there. That he is the president of the Senate, just there to break ties when the vice president is not able to be at a Senate gathering. Chuck Grassley will fill in for him. Beneath the president of the Senate and then the president pro tem, you will have a majority and a minority leader and a majority and a minority whip. So that's similar to the House of Representatives. Currently, John Thune is the majority leader, a Republican. I think he represents South Dakota, maybe. And then Chuck Schumer is the minority leader. He's a Democrat. Underneath all of these leaders of the House and of the Senate are committee members. Committees are where legislation really gets accomplished. A lot of the work of lawmaking occurs in smaller committees. And there are different types of committees, 4 different types that we'll go over now. There's something called a standing committee, and these are the most active committees. They're permanent committees. So the House and the Senate each have a list of standing committees that are permanent. They always exist. They're meeting regularly. And a standing committee is where legislation is first proposed and worked on. So they'll conduct research, hold hearings, debate, amend, revise, and so forth. Any piece of legislation, it always starts out here in a standing committee. The next type of committee is called a joint committee. They're informational only committees, so they're temporary. They'll be organized just to address a key narrow issue that Congress is having to consider. Then you'll have a conference committee, also temporary, and they are there to reconcile disputes between the House and the Senate on legislation. We'll talk a little bit more about conference committees when we look at how a bill becomes law. But generally, this is where if the Senate proposes a bill and votes on it, approves of it, the House has to approve of the same bill. There can't be any sort of conflict between the House and the Senate on any piece of legislation, or it can't go to the president's desk. So when they wind up at an impasse, the House and the Senate will together form a conference committee to reconcile their differences and come up with a single bill that everybody agrees on, or at least a majority of both chambers agrees on, to be sent to the president's desk. Then the last is a select committee. These are formed ad hoc in order to conduct special investigations. An example would be like the January 6th committee. They were a select committee that was investigating the attack on the Capitol building after the 2020 election. For a second now, let's look at the way members of Congress tend to behave. They are all lawmakers, but political scientists have come up with a variety of categories to describe exactly how they do the business of lawmaking. You could categorize some members of Congress as delegates, exhibiting the behavior of a delegate, which means the representative is just going to be sort of like a puppet of the constituents. He or she will vote just according to the will of his or her constituents, without any real regard for their own personal judgment or feelings about the legislation. Or a representative could be considered a trustee. And in that way, the representative is going to vote primarily according to his or her conscience or judgment, maybe just following the party line, and won't give as much regard for, or at least check on, the will of the constituents who elected him or her. Most members of Congress are probably considered something of both, and they would be labeled politicos. So on matters that are sort of mundane or tedious, that voters are not really paying very close attention to, they will, in those instances, act as a trustee and vote along the party line. But for those hot button issues where voters are really watching and paying attention, they'll be more likely to check in with their constituents, find out what the people want before casting their vote for or against a bill. So those are the three categories that we've come up with: delegate, trustee, and politico. But you can also look at the demographics of Congress and take into consideration how those demographics might affect their representation. Demographics are a reference to a person's age, race, gender, educational attainment, socioeconomic status, religious belief. Those are called demographics. And we can sort of analyze the activity of Congress or members of Congress and compare that and look for trends that might be consistent with their demographics. I've got a few slides in here to demonstrate that. For example, here is the racial makeup of the current Congress. And you can see that there is a roughly equivalent split as far as African American and Caucasian goes. Um, it's it's still pretty slanted towards Caucasian though. But then you can see that Hispanic Americans have certain representatives here. You can see that is growing over time as well. Then this is the blue is Asian Americans have some representatives there. And then this top little narrow line refers to American Indians and Alaska Natives. Um, so you're seeing sort of a growth in diversity, racial diversity, but still Congress is largely Caucasian. This is showing now the number of women serving. So here's the gender demographic, and it has gone up remarkably over the past several years. I don't have his current data. I think, yeah, this goes up through, oh, good. It goes all the way up through the current Congress here. 118th Congress is where we're at right now. And you can see that 29% of the House are women and 25% of the Senate are women. So it's getting a little bit more balanced, but still mostly men. I believe this shows the religious background of members of Congress. I'm afraid that, there we go. Yes, okay. Protestant makeup is still slightly in the lead. We have quite a few Catholics now, and then some of the more minority religions are here. So it's still heavily Protestant, definitely heavily Christian, but then there is representation by some religious minorities. This is the age break, and as you might expect, it is mostly on the older side, although it's getting younger. Let's see, the very top line are the youngest. So most of the members of Congress would be considered baby boomers, having been born in these 2 decades here. Okay, so that's the descriptive representation of Congress that you may or may not believe that the demographic affects their lawmaking behavior, but studies suggest that it does have an influence on them. I have here the word caucus just to help you understand that demographic groups do organize themselves within Congress. They organize their lawmaking activity and really to help members of their demographic get elected. So there's a women's caucus that helps women get elected into Congress. There is an African American caucus to help African Americans get elected. And I imagine there's some for other racial and races and ethnicities as well. Those are just a couple of examples. When you look at Congress as a whole and you compare it to the entire nation, so looking at this huge picture here of all the members of Congress, you can compare that to the demographic makeup of the entire nation and ask yourself whether it is proportional. It is not, sadly. It's getting better, but it is still heavily white and heavily male. But we're doing better. But that's what collective representation refers to, is the extent to which the body of Congress proportionally reflects the demographics of the nation. Okay, now we're on to how a bill becomes law. I bet you all studied this in high school. You might have even watched the little video of how a bill becomes law. I'm going to go over it, just the classic process. We're not going to get into the more modern nuances, at least not for just this survey course on American national government. But I want to start out by pointing out something important, actually. Congress is the slow branch of government, and that is by design. We complain a lot about Congress never getting anything done, but the reason it doesn't get a lot done is because it can't, because of the way it was designed. Here is a little bit of language from a Federalist paper that we read, and I want to read it again. The effect, he's referring to the nature of a republic. The effect of the first difference is, on the one hand, to refine and enlarge the public views by passing them through the medium of a chosen body of citizens. He's referring to Congress right there. In a republic, we use representatives to do the work of our national government. And so when we pass the views of the public through Congress, the expectation is that they can see the bigger picture and understand better how a particular public policy will affect the nation as a whole, what it will cost, what some of the other smaller consequences are of that legislation, and better discern the true interests of their country. Because of that, they are expected to move slowly, to be contemplative, and think through the consequences of a particular piece of legislation. So when we go through this classic process of how a bill becomes law, and you see the length of the process and the complications in the process, understand it was because we wanted the views of the public to be tempered by this chosen medium of a chosen body of citizens. It's all to prevent the oppression of minorities. It was to prevent factions from gaining too much power and oppressing the civil liberties of minority groups. Okay, so how a bill becomes law, we start with the Constitution. Article 1, Section 7 provides that all tax legislation must originate in the House. That is because the House was considered to be the most closely tied to the voters. Originally, the Senate was elected by state legislatures. The House was elected popularly by the people in their district. So they were more closely tied to the people, and for that reason, they were the appropriate body to be introducing tax legislation. Other than tax legislation, though, bills can be introduced in either chamber of Congress. They could start in the Senate, they could start in the House, but they'll start in one or the other. The next clause in the Constitution that applies is the presentation clause. Both chambers have to present the same bill to the president. They can't be sending in different versions of a law. They have to have the same exact law before it can go to the president. So Congress has to act all together. All 535 members must work together to get legislation written. And if a majority of both chambers agree on the same bill, only then will it go to the president's desk. A bill does not become a law until the president signs it. The president has the power to veto a bill if he or she does not support it, and then send the bill back to the originating chamber for reconsideration. As I mentioned, though, Congress can override a president's veto with a supermajority. So if 2/3 of both the House and the Senate really want a bill to become law, they can do it over the president or against the president's wishes. But otherwise, before a bill will ever become an actual law, the president will have to sign it. And this, again, is to ensure that legislation is considered carefully. We look at the implications of it financially and socially. Bills will not become a law unless a majority of Congress and the president support it, or a supermajority of Congress support it. So it's got to have a broad-based support before a bill can become law. That takes a long time to build that sort of consensus. And we want to have that so that more rash measures that might be oppressive of minority groups, I'm not talking about racial or gender minorities, but just the opposition to a bill will still yet have their civil liberties protected. So that is to prevent a majority faction from oppressing the liberties of the minority that is opposed to a bill. This is a graph that kind of shows the the overall process of how it goes through. So I'll go over it quickly. It starts with an idea. Of course, someone comes up with an idea for a new piece of legislation, but only a member of Congress can get converted into legislation. So you have the idea presented by someone, anyone. It will be then passed to either a member of the House or the Senate and written in the form of a bill. The bill is given a number and then introduced to either chamber. So that is, here's the idea. It gets written as a bill, given a number, and introduced in either the Senate or the House. And the first place it will go to a standing committee. That's one of the 4 committees I talked about earlier. So the standing committee will meet, review the bill, discuss it. They might change it. They'll usually do a lot of research on it. They may appoint a joint committee to look at it carefully, do some research on it. They may hold hearings, call in experts to really evaluate the bill. But then the committee itself will vote up or down. Do we want the bill to move forward? They can kill it by voting it down, or they can move it forward by voting it up and sending it to the full Senate. And this is the same thing is happening here in the House. It's the same process there. It'll go to the floor of the House or the floor of the Senate, depending on where it was introduced. And there'll be additional debate and discussion, amendments, and so forth before a floor vote is called. If a majority of the House or the Senate is in favor of the bill, it'll move to the next step. If a majority does not approve of it, it is killed. It dies there on the floor. But once a majority of one chamber gets a majority for a bill, it will pass then over to the other chamber. And it's got to start off at the very beginning. It's got to be introduced into the other chamber, go through this committee process again, go through the floor vote again. Only when both the Senate and the House agree exactly on the same bill will it go to the president's desk. When there is a difference of opinion between the Senate version and the House version of a bill, a conference committee will be formed to resolve those differences. And then, only then, can they send the bill to the president's desk here. The president has the option to veto it and send it back, although the veto can be overridden by a supermajority of Congress. Or if signed, it will become a law. And that is the classic legislative process. Okay, our last topic then is going to be on the election process for Congress. So I'm going to always refer you back to the Constitution when we're discussing things involving the operations, the institutions of government. The 4th section of Article 1 provides that the times, places, and manner of holding elections for senators and representatives shall be prescribed, so that means decided, in each state by the legislature thereof. So state legislatures play a very large role in the process by which members of Congress are elected. Now, Congress does have some influence as well. They can change what the state legislatures do. But by and large, the people calling the shots in congressional elections are state legislatures and political parties, as we'll talk about in a minute. But first, I'm going to go back over some elements of the Constitution regarding election. The Senate is described in Section 3 of the first article. And again, they are elected for 6-year terms with no term limits. They are currently elected by a popular vote of all citizens within a state, so that's statewide representation. It was not originally that way. Originally, state legislatures elected senators, so that gave state legislatures greater power in Congress, but the 17th Amendment changed it to just a straight up popular vote for senators. We elect 2 senators per state, regardless of our population, And so they will be there speaking for, they are elected by all citizens within a state, speaking for all citizens within a state. So it's this fairly simple thing. Matters get a little bit more complicated in the House of Representatives. As I mentioned previously, members of the House serve for only 2 years, so it's much shorter term. They have no term limits. They have always been elected by popular vote, but not statewide. Each state will have one representative, but beyond that, the number of representatives each state will get is determined by the state's population. That was part of the Great Compromise to accommodate states that had a high population to reflect popular sovereignty as well. So we would conduct a census every 10 years to determine the population of our nation, the population of each state, and then you apportion seats in the House of Representatives by population. And that's where things get really complicated. In 1789, there were far fewer people in the United States of America. And so the proportion of representative to citizens was one representative for every 30,000 citizens of the United States. So that seems pretty fair. That's about the size of Greenwood. Population has grown, obviously. It's grown quite a bit over the past 240 years. But it occurred at a fairly steady basis, although there were huge spikes in population growth at certain times. But that increase in population meant the number of representatives in the House grew as well, and it grew quite a bit. And at a certain point in 1929, Congress had to put a lid on it, and they set the cap at 435 members. So that's how many seats in the House of Representatives. So if you wonder where 435 came from, it came from a piece of legislation. Congress wrote a law that set the maximum number of seats in the House of Representatives at 435. So you start with that maximum, and then you distribute those seats as needed every 10 years to the states based on their population. So everybody gets their proportional share, or each state gets its proportional share of seats in Congress, proportional by population as determined every 10 years. That's what biennial means, every 10 years. There is a law that was, I'm sorry, I do not recall exactly when it was passed, but it requires that each representative represent a roughly equal number of citizens so that each citizen's voting power is the same. This law was a precedent of the U.S. Supreme Court, and I think it was in the 60s, but I'm sorry, I just don't recall exactly when the law was set. But that is where we get the idea of proportional representation nationwide. Every citizen should have the same voting power. And so that meant that every representative in the House must be representing a roughly equivalent amount of people. So that's what we mean by proportionality. In order to accommodate that proportionality, state legislatures had to carve up their states into representative districts. And I'm going to fast forward just to show you, this is the way South Carolina was divided up into representative districts. So the colors are showing the designations of the 7 districts. So that biennial census process and the allocation of those 435 seats resulted in South Carolina getting 7 seats in the House of Representatives. And this is how those borders, the colors show the borders of each representative district. So each of these will get to elect one of the 7 representatives of South Carolina in the House. And these are the names. I showed you their pictures on a previous slide. Okay, so those are the representative districts from South Carolina. Now, as you might imagine, populations shift people move. They don't always stay in the same city their entire lives. And there tend to be trends and movements of people. Lately, it's been movements from rural areas into urban areas. So that requires, in order to maintain proportionality, that requires the state legislatures to adjust the boundary lines of the districts from time to time so that we maintain that proportionality. So that means they've got to redraw the lines. And that process of redrawing the lines, kind of to adjust for population shifts, is known as redistricting. So again, this happens about every 10 years, immediately following the census, when there are marked shifts in population. Because state legislatures are doing this process of redistricting, and because state legislatures are political bodies, party politics will always be influencing the redistricting process. And that may sound somewhat corrupt to you. You may think that it ought to be illegal. However, it is not. It is legal for political parties who control the state legislature to redraw district lines in a way to maximize the power their party has in Congress. They will draw it in a way to sort of pack together voters, their party's voters, into districts, pack them together so that they form a majority voting bloc within their district that creates a safe seat for their political party in the House of Representatives. This is all known as gerrymandering. If you want to, you can Google that word, gerrymandering, and it'll give you the story of how that name came to be. But it really is just the political maneuvering that state legislatures will perform to maximize the political party's power in Congress by redrawing lines, kind of packing together voters for their party into districts so that they have a voting bloc and can always control their party's success in a particular district. In most states, state legislatures are controlling that process, but there are a few where like a bipartisan, so a split 50-50 between Republican and Democrat will get together as a commission and handle the redistricting process in a more fair way. But still, in most states, it is a very politicized process. And as I mentioned, it's referred to as gerrymandering. Another consequence of this process came about after the ratification of the 14th and 15th Amendments. So both of them were a positive effort to provide for equality for former slaves and African Americans. So the 14th Amendment made sure that African Americans were considered citizens of the United States and treated the same way as Caucasian people were. The 15th Amendment gave African Americans the right to vote. So good, these were both positive results. But the consequence was that the 3/5 clause was removed from the Constitution, and suddenly the population of the South the population didn't change, but the way people were counted changed. So no longer were we only counting 3 out of every 5 slaves. We were now counting all people within the Confederate States. So that's a huge increase in their population for purposes of representation, meaning they got greater power in Congress because their population grew. That meant they had more representatives in the House. So it gave them greater political power. And they exploited that power to disenfranchise African Americans, kind of reversing the positive effects of the 14th and 15th Amendment. They maximized it was mostly like the former plantation owners, the former slave owners started to control the election process. And so they excluded African Americans through specific measures that we call now Jim Crow. So that's when it was after Reconstruction ended in the late 1800s. these measures were passed to prevent African Americans from voting. And it took 100 years for anything effective to really undo that discrimination. The Voting Rights Act was passed in 1965 to get rid of those Jim Crow laws that prevented African Americans from voting. They did so through something called a pre-clearance requirement, where any of the former Confederate states or states that had a history of discriminating against African Americans, they would have to get approval from the Attorney General of the United States over any changes to their laws. And so the end result is most Southern states had their election laws undone. The Jim Crow laws were undone by the national government through this sort of pre-clearance process. The laws were rewritten so that they were fair and included African Americans. One of those efforts is known as the establishment of majority-minority districts, which is districts. So you're talking about redistricting. They were forced to redraw their district lines so that African Americans could be sort of packed together in a single district and have great voting power within a district and be able to elect the representative of their choice. That's what a majority-minority district was. And this worked. The turnout rate in voting by African Americans boomed following the 1965 passage of the Voting Rights Act. It was very effective. Sadly, however, that the part of the Voting Rights Act that provided for this pre-clearance process was invalidated by the U.S. Supreme Court in the year 2013. The case was called Shelby County versus Holder. We'll study it later in this course when we were looking at civil liberties. But they removed that pre-clearance requirement. So now any sort of discriminatory conduct in the redistricting process has to be challenged by individual citizens filing lawsuits against the state legislatures. All right, our last topic then related to electing members of Congress is going to be on campaign finance, the influence of money in elections. You've got an assignment related to this in this learning module where you'll hear the story told and look at a website that kind of describes the history of money's influence in politics. But I am going to kind of go over it briefly. You can probably expect that the more money that is spent on a race has increased. The amount of money has increased. And the person spending the most in his or her election typically wins. So there is a definite correlation between the amount of money spent on a person's candidacy and the success of that candidate. That's what you're seeing here in this graph. The candidate who spends the most usually wins the election. That's just correlation, not causation. There are other factors at play, but I'm not going to get into that for this lecture. But what we will look at is just recognizing that tight connection between money and success in congressional elections. We're going to look at how the country tried to make some reforms to remove any potential for corruption there. The earliest efforts to remove corruption occurred in the end of the 19th century, and it was really just focused on big corporations that had formed during the Industrial Revolution, trade organizations, labor unions that were being heavily influential, picking candidates, funding their candidacy, and it was sort of a quid pro quo situation. So they would promise to vote as a block, elect somebody in exchange for favorable legislation. So that's a quid pro quo. favors being exchanged. You vote for me, I'll give you the laws you want. So that's corruption right there. That quid pro quo was corruptive. And the earliest efforts at reform were to eliminate that, to place limitations on the amount of money that an organization could donate directly to a candidate. A consequence of that early legislation that limited those donations was the formation of PACs. A PAC is a political action committee. They are organizations that are designed specifically to raise money for a specific candidate. They are often run by industry organizations today, and not a specific party or candidate. But their job is to get people elected. The job of a PAC is to get a candidate elected. So that's they were formed, towards the end of the 19th century, early 20th century. They will collect donations from individuals and then spend that money towards electing a specific candidate, or more than one. It can be multi-candidate. It doesn't always have to be just one person. There is a spending cap, though, so a maximum amount that PACs can spend. The current law that governs campaign finance is called the Federal Election Campaign Act, and it was originally enacted in 1971. It was there specifically to crack down on the corruptive influence of PACs, putting those limitations on the amount of money that could be donated by a PAC to a candidate, the amount of money that a PAC could spend in support of a candidate. But at first, it didn't have any sort of enforcement arm to it. So the laws were passed that had these donations and spending maximum limits, but there was no one there to check up on the candidates to make sure they weren't breaking the law. And that's where we had to make some amendments. Watergate is that political scandal that involved Richard Nixon. Your assignment is to watch a short video about the Watergate scandal and its connection to campaign finance reform. So you'll get more information about what Watergate was exactly and the way it impacted campaign finance reform. For now, I'll just say that it prompted an amendment in 1974 that created the Federal Election Commission, which is that enforcement arm that we needed all along. This is a group of individuals. It is bipartisan, so equal Republican to Democrat, and they monitor compliance with our campaign finance laws. It did impose, as I said, significant limitations on the amount of money that a PAC could donate to a candidate and the amount of money that could be spent on electing a candidate. And that drew criticism pretty quickly. A lawsuit was filed in 1976. It was known as Buckley versus Valeo. And in that case, the plaintiff challenged the limitations on donations and spending that were part of the Federal Election Campaign Act, and they won in part. So the result of the decision, Buckley versus Valeo, was a distinction between donations and spending. So post Buckley, then you are limited on the amount of money that can be contributed directly to a candidate, but you cannot limit spending in support of a candidate. So it's that distinction between contributing directly to a candidate and then spending money on political expression. So contributions directly to a candidate have the most corruptive power. That's where that quid pro quo goes in. I give you money, I contribute money to your campaign, you give me favorable treatment in return. That can be limited. Contributions or donations to a candidate can be and are strictly limited. Spending, however, can't be limited because as far as the U.S. Supreme Court is concerned, money is speech. And so when people are spending money on commercials and publications in support of a candidate, they're expressing themselves. That is a First Amendment right. And that's what was recognized first in Buckley versus Valeo, that there is a First Amendment right to make your political opinions known, who you support for a candidate, who you oppose. So that cannot be limited, only those direct contributions to a candidate. So following Buckley, with this limitation on contributions coming into play, we had to focus more on spending in order to get candidates elected. And that's what soft money is. It's money that is not contributed directly to a candidate, but is yet spent on campaigns, particularly on issues, political issues that a candidate might favor or oppose. That's known as soft money because it's not regulated. Hard money is regulated. Hard money refers to those contributions that are limited. Soft money refers to the spending that is not connected to a particular candidate, but is more issue driven. Soft money, the amount of soft money being spent in election increased dramatically in the 1980s and the 1990s to the point that it alone became a corruptive influence. And so in 2002, two members of Congress, one a Democrat, one a Republican, formed a bipartisan bill known as BICRA to try to regulate or limit the influence of soft money. There were some specific provisions to their bill. For example, it limited contributions to parties. So that trick of soft money, giving your donations to a political party for like get out the vote drives, party building efforts, that sort of thing, that type of spending could be limited, according to BICRA. It also imposed the requirement that candidates endorse their advertisements. It's known as the stand by your ad provision. That's why if you see the political commercials, there's that little byline, I'm so-and-so and I approve this message. Right, that's called the stand by your ad provision that was put into play with BICRA. And they also put some pretty tight restrictions on something known as electioneering communications. There were some pretty strict limits on the ability of organizations, corporations to pay for these political commercials. So a lot of campaign spending was being devoted to these commercials, and the commercials were shocking and provocative and often based on sketchy information, not really factual. They were slanted and unfair. And so the McCain and Senator McCain and Senator Feingold wanted that sort of spending to be strictly limited. So that drew a lot of criticism from members of the public, and we had another lawsuit known as Citizens United versus Federal Election Commission, the FEC. And that's the most recent one that at least that we'll cover in our class. Citizens United kind of takes us back to the distinction between contributions and spending and First Amendment protection for political expression. The U.S. Supreme Court held that the part of BICRA that limited those electioneering communications, those advertisements, violated the free speech rights of the organizations who were funding those commercials. So what they essentially found was that corporations had First Amendment rights. So it's not just individuals having First Amendment rights. That's what Buckley versus Valeo established and will protect individual political expression. Citizens United stands for the proposition that even corporations have First Amendment rights, and they cannot be limited in the amount of money they spend on political commercials. So the result of Citizens United, a lot more spending on these electioneering communications, a lot of spending on commercials that favor candidates or that take a position on specific issues connected to candidates. So spending increased dramatically following this decision. And so did the formation of something known as super PACs. So a super PAC is an independent expenditure only committee, meaning independent, meaning they are not associated with a specific candidate. So a regular PAC, its business is getting a specific candidate elected. A super PAC is not associated with a particular candidate. They are united by an interest on a particular issue, and they can spend vast amounts of money to advocate for the election of a candidate that supports or opposes the issue they're concerned with. That's what a super PAC is. And most of the spending in elections now is done by these super PACs. And their spending is unlimited because of the Citizens United decision. Another problem in campaign finance is called dark money. Even though the FECA requires, so that's the Federal Election Campaign Act, requires donations to candidates to be identified. The donors have to be identified. They can't give anonymously. So it should be public. We should be able to know what person or organization is donating to a particular candidate or donating to their not being elected. So what I'm getting at is the law, Federal Election Campaign Act, requires donations to be made public, the identity of the donors to be made known to the public. So voters know who candidates are receiving money from. Unfortunately, due to some of our tax laws, nonprofit organizations are not regulated by the FECA, so they can give anonymously. So all an organization has to do is organize itself as a nonprofit organization, and they can absolutely avoid having to disclose their identity and then donate tons of money to a candidate. That's known as dark money. And dark money has a lot of influence over how candidates are elected. People are giving in the dark. So the public doesn't always know exactly who is giving what money to which candidate. This last slide is to sort of cap off our discussion on campaign finance. Incumbents, an incumbent is someone who already holds a political office and is running for re-election. So they're referred to as an incumbent because they're already there and they're running for re-election. It is much, much easier for an incumbent to get reelected than it is for someone new to get into Congress. And that is demonstrated here by this chart, the reelection rates across the span of about 50 years. I don't have the last 10 years data. I looked, I couldn't find a good chart on it. But I imagine the trend is still the same. So why is it that incumbents, why is it easier to get reelected than elected? Well, a lot of it has to do with name recognition. Once you're elected to Congress, your name is known. And so you can get votes simply because you're familiar. It's also because you have a proven record. You've already been serving in Congress. You've probably accomplished something that made people happy. So you can highlight the things you've already done and easily convince voters to reelect you, allow you to stay and do even more. Another reason that this is called the incumbency effect. Another advantage they have is they often can influence state legislatures on the redistricting process and kind of manipulate the drawing of the redistrict lines in such a way as to pack their supporters into a voting district and give themselves a safe seat. So a majority of their voters will be in the district that they represent, and so it's easy for them to get reelected. Those are just some of the reasons why it's much easier to get reelected and why Congress can become sort of entrenched and stagnant. It's the same people there often, and they are able to get reelected over and over again because there are no term limits in Congress. So while it's good to have consistency and to have steady representation, allowing Congress to really evaluate laws and work together and get things done through a very contemplative considered fashion, it's also a little bit problematic because it's difficult for new ideas to get any play in Congress. You have to convince the incumbents to try something new. Fresh faces who might bring fresh ideas find it difficult to get into Congress. Okay, so that will be the end of the lecture. Move ahead now to your module assignments.